Picture this situation. You are 72 years old. You have lived inside your house for 3 decades. The mortgage is completely paid off. You raised your family within those walls. Every room carries a memory attached to someone you love. Then one morning, without any warning, you experience a stroke. You pull through, but the damage is significant. Speaking is impossible. Writing your signature is impossible. Making any kind of decision on your own is impossible. Your daughter rushes to your financial institution to cover your property tax payment before the due date arrives. She walks through the front door. She provides your name at the counter, and the representative behind the desk tells her something devastating. "We apologize, but you possess no legal standing over this account. Your daughter cannot settle your outstanding bills. She cannot reach your savings. She cannot sell your property, arrange refinancing, or even handle basic upkeep on your house." Everything comes to a complete standstill, while the invoices continue arriving. This situation is not unusual or rare. According to the Consumer Financial Protection Bureau, variations of this exact scenario unfold for families throughout America on a daily basis because 5 straightforward documents were never completed and filed. My name is Floyd, and I serve as a senior policy analyst focusing on retirement finance, Social Security regulations, and the legal protections designed specifically for Americans over the age of 60. Today, I am walking you through the 5 most critical documents every homeowner over 60 must complete before a crisis arrives. These are not personal opinions. These are not internet rumors. Every piece of information I share comes directly from official government resources, including the Consumer Financial Protection Bureau, Medicare.gov, the Internal Revenue Service, the Social Security Administration, and verified research published by AARP. Here is the reason you absolutely need to remain through the entire presentation. There is a concealed tax situation I will explain when we reach document number 5. This particular issue can drain hundreds of thousands of dollars from your children through capital gains taxation, and it all hinges on a single choice you make regarding your property while you are still living. The overwhelming majority of homeowners have never been warned about this, but by the time this video concludes, you will have the full picture. So let us get started. Allow me to introduce you to Robert. Robert was 67 years old. He spent his career as an electrician and had retired in Ohio. His home was completely paid for with no remaining mortgage. His monthly income included a modest pension alongside his Social Security payment and a small amount held in savings. Robert thought of himself as a responsible and organized person. He had communicated his wishes to his 2 grown children, David and Karen, in clear and direct terms. The house would belong to Karen since she lived close by. David would receive the savings account, simple, balanced, and fair. He shared this plan with both of them during a Thanksgiving gathering in 2023. Everyone listened, everyone agreed, but Robert never committed any of it to paper. He never executed a will. He never established a power of attorney. He never recorded a transfer on death deed. His reasoning was straightforward. His children already understood his intentions. That should be sufficient. Then, during the early months of 2025, Robert suffered a serious fall. He struck his head and developed internal bleeding that left him cognitively unable to direct his own affairs. Karen visited his bank attempting to cover the property tax payment. She was denied entry to the account. She contacted the Social Security Administration seeking to manage his monthly payments. She was informed she carried no authority whatsoever. She attempted to coordinate repairs to the house so Robert might eventually return home from the rehabilitation facility, but she lacked the ability to execute any agreements on his behalf. David, in the meantime, retained an attorney and initiated court proceedings to obtain legal guardianship. Almost immediately, Karen and David found themselves on opposing sides of a dispute. The court system became directly involved. Attorney costs began accumulating rapidly. Robert's home sat completely empty for 11 months. Property tax obligations went unmet. A lien was recorded against the property. 11 months, no legal standing, no advance preparation, and the house came dangerously close to being lost entirely. Every single consequence, from start to finish, could have been prevented completely if Robert had prepared 5 documents ahead of time. Let me walk you through exactly what those documents are. Document number 1. Durable Financial Power of Attorney. This represents the single most essential legal instrument available to any homeowner over 60. A durable financial power of attorney grants someone you have chosen, referred to legally as your agent, the recognized authority to manage your financial matters when you are no longer capable of doing so yourself. This encompasses paying your housing loan, overseeing your bank accounts, addressing property tax obligations, and potentially arranging the sale of your home if circumstances require it. Pay close attention to the word durable, because it carries tremendous significance. According to the Consumer Financial Protection Bureau, a conventional power of attorney actually loses its effectiveness the moment you become incapacitated. That is precisely the moment when you need it functioning at full strength. A durable version remains fully valid and enforceable even after your capacity to make independent decisions has been lost. Here is the misconception that trips up countless seniors. Many believe their husband, wife, or adult child can automatically step forward and take over their financial affairs. The Consumer Financial Protection Bureau addresses this directly and unambiguously. That assumption is entirely incorrect. Without a properly executed durable power of attorney, no family member possesses legal authority to intervene. Not your partner, not your son, not your daughter. Without this document, your loved ones face only one available path: petitioning the court for guardianship or conservatorship. The CFPB characterizes this legal process as time-consuming, financially draining, and completely public. AARP has reported that conservatorship proceedings frequently generate family disputes, competing legal claims, and outcomes where the court rather than your own family determines who manages your personal affairs. One additional matter deserves your immediate attention. The Social Security Administration now offers something called an Advanced Designation of Representative Payee. This provision allows you to identify up to 3 individuals who would be authorized to manage your Social Security income if you ever lose the capacity to handle it personally. You can establish this designation right now through your personal My Social Security profile at SSA.gov. I strongly encourage you to complete this step today without delay. Document number 2. Last Will and Testament with specific property provisions. Now we turn to the subject of your will. Not simply any will, but one that directly and specifically addresses the future of your home. According to the Consumer Financial Protection Bureau's official resource guide for older Americans, a will is the legal instrument through which you communicate your wishes regarding the distribution of your possessions upon your death, including your real estate. The misunderstanding that creates enormous problems for families is this: an enormous number of seniors believe that verbally expressing their wishes to family members is legally sufficient. It is not. Without a properly executed written will, your home transfers according to your individual state's intestacy statutes. This means the state legislature rather than you personally determines who receives your property, and that formula may direct your home to people you never had any intention of benefiting. AARP states this plainly. Without a will, state laws and probate courts take over, introducing unnecessary delays and financial costs. This can produce what AARP describes as tangled titles, meaning the individual residing in the home does not appear as the legal owner of record. That person cannot sell the property. They cannot arrange refinancing. They cannot obtain insurance coverage. In certain situations, they cannot authorize even routine maintenance. And the financial toll is significant. AARP estimates that probate without a valid will can extend beyond a full year and consume more than 3% of the estate's entire assessed value. On a property estate valued at $1 million, your heirs could forfeit more than $30,000 to probate expenses alone. Do not allow that outcome. If you are over 60 and you own residential property, a will is not optional. And if one already exists, retrieve it and examine the date of execution. If it was prepared before any significant life transition, such as a divorce, the passing of a family member, or the arrival of grandchildren, it very likely requires updating. Free legal assistance for individuals over 60 is accessible through the Elder Care Locator by dialing 1-800-677-1116. Document number 3, Transfer on Death Deed or Revocable Living Trust. This particular document is one the majority of seniors have never encountered, yet it may carry the greatest practical power of everything on this list. A transfer on death deed, commonly abbreviated as a TOD deed, is a recorded legal instrument stating that upon your passing, your home transfers immediately and directly to the individual you have named. No probate court involvement, no legal proceedings, no waiting period of any kind. According to the Consumer Financial Protection Bureau, this option is simpler to establish and less costly than creating a trust. As of 2026, approximately 30 states, along with the District of Columbia and the United States Virgin Islands, recognize and permit TOD deeds. You record it through your local county recorder's office, and you retain complete ownership and control of your home for the remainder of your lifetime. You retain the ability to modify or revoke it entirely at any point. In states that do not authorize a TOD deed, the appropriate substitute is a revocable living trust. According to consumerfinance.gov, a living trust enables you to transfer title to your home into a trust structure that remains under your complete management during your lifetime. You serve as your own trustee throughout this period. When you pass away or lose decision-making capacity, a successor trustee you have already designated steps into that role and manages the property without any court involvement whatsoever. However, here is the critical error that undermines this entire approach. Many individuals establish a living trust and consider the matter resolved. It is not. The Consumer Financial Protection Bureau is explicit on this point. A living trust accomplishes absolutely nothing until your property is formally transferred into it. This requires retitling your home in the name of the trust itself. If you fail to complete this step, your property will still pass through probate regardless of the fact that you invested money in establishing the trust. Additionally, the CFPB cautions that trust services are sometimes promoted by individuals and organizations operating with questionable motives. If anyone contacts you offering to arrange a trust, investigate their credentials thoroughly and consult with an independent attorney before proceeding. One more element requires your careful attention. According to Medicaid.gov, state Medicaid programs are mandated under federal law to pursue recovery of expenditures from the estates of individuals aged 55 and older who received nursing facility or home-based care services. States may even place liens against your property during your lifetime if you are permanently placed in an institutional care setting. However, and this distinction is critically important, states are prohibited from pursuing recovery when you are survived by a spouse, a child younger than 21, or a child of any age who is blind or disabled. Understanding these regulations thoroughly before making any property transfer decisions is absolutely essential. Document number 4, Advanced Healthcare Directive. This is the document that protects your physical well-being and medical care rather than your financial assets. According to Medicare.gov, an advanced healthcare directive contains two distinct components. The first is a healthcare proxy, also referred to as a durable power of attorney for healthcare, which designates a trusted individual to make all medical decisions on your behalf when you are unable to communicate your own wishes. The second component is a living will, which documents precisely which medical treatments and interventions you want administered or withheld when your life is in jeopardy. This encompasses decisions regarding dialysis treatment, mechanical breathing assistance, cardiac resuscitation, and nutritional support through feeding tubes. It also records your preferences regarding organ and tissue donation following your death. Here is the misunderstanding that places many seniors in a vulnerable position. Numerous older adults assume their financial power of attorney extends to cover healthcare decisions as well. It does not. The Consumer Financial Protection Bureau is absolutely unambiguous on this distinction. A financial power of attorney and a healthcare directive are entirely separate legal instruments serving different purposes. You require both independently. And here is another frequent error that defeats the entire purpose of having the directive. People complete the document and then store it in a filing cabinet without informing anyone of its existence or location. If your directive cannot be located during a medical emergency, it provides no protection whatsoever. Copies must be provided to your primary physician, your hospital of record, your designated healthcare proxy, and at least one additional trusted family member. Here is genuinely encouraging information. Medicare covers advanced care planning conversations at no charge to you when conducted as part of your scheduled annual wellness examination. The next occasion you visit your doctor for that yearly appointment, raise this subject directly. Request their assistance in formally documenting your medical preferences and treatment wishes. You possess the legal standing to do precisely that. Medicare.gov explicitly confirms that you hold the right to implement your healthcare plans as you see fit without facing any form of discrimination. AARP has documented that the absence of a healthcare directive represents one of the leading causes of families becoming entangled in conservatorship proceedings. Protect your family from that experience. Document number 5, Homestead Exemption and Senior Property Tax Exemption Application. We have now arrived at document number 5. This is the one that generates tangible financial savings for you annually and contains the concealed tax situation I referenced at the very beginning of this presentation. The majority of states and numerous municipalities provide homestead exemptions or senior-specific property tax relief programs. These initiatives reduce the taxable assessed value of your home, which directly reduces your annual property tax obligation. Certain states additionally offer tax freeze programs that establish a ceiling on how much your property taxes can increase from year to year. But here is what consistently catches homeowners completely unprepared. These exemptions do not apply automatically. AARP is emphatic on this point. You must submit a formal application to your local county assessor's office or tax authority. In many jurisdictions, renewal is required annually or every few years. AARP references one housing professional who observes that anyone can overlook a renewal notice, particularly older adults who receive substantial volumes of mail. Miss the filing deadline, and you pay the full unexempted tax rate. Accumulated over 10 or 20 years of retirement, that oversight can represent tens of thousands of dollars in completely unnecessary payments. On the federal taxation side, the Internal Revenue Service now provides Form 1040-SR, a tax return formatted specifically for seniors featuring enlarged print. Beginning with the 2025 tax year, an enhanced deduction has been introduced for taxpayers 65 and older. According to IRS Publication 554, if you are weighing the decision to sell your home, you should know that you may qualify to exclude up to $250,000 in capital gains from your taxable income or $500,000 for married couples submitting a joint return. The requirement is that the property served as your primary residence for at least 2 of the 5 preceding years. This provision is documented in IRS Publication 523. Now we reach the concealed tax situation I promised to reveal. This is the element carrying the most significant financial consequences for your family. If you deed your home to your child as a living gift, your child receives your original acquisition cost as their tax basis. Let me translate that into concrete figures. Suppose you purchased your home for $50,000 40 years ago. Today, that same property carries a market value of $400,000. If you gift it to your son while you are still living, his cost basis remains at $50,000. When he eventually sells that property, he faces capital gains taxation on the full $350,000 difference. However, if you retain ownership of the home in your name and your son receives it through inheritance following your death, an entirely different tax treatment applies. Under Internal Revenue Code Section 1014, the cost basis adjusts upward to reflect the fair market value on the actual date of your passing. His basis therefore becomes $400,000. If he sells the property at that same $400,000 value, his capital gains tax obligation equals precisely zero. That single decision, choosing between gifting and inheritance, could determine whether your child preserves their financial security entirely or surrenders a substantial portion of it to federal and state taxation. This information is drawn directly from IRS Publication 551 and the official IRS guidance page addressing gifts and inheritances. Please consult with a qualified tax professional before transferring your property to any other person under any circumstances. You now possess knowledge of all 5 documents. But information alone without corresponding action produces absolutely no change in your circumstances. Here are 3 concrete steps I am asking you to take during the coming week. Not sometime next month, not eventually. This week specifically. Step 1. Gather and complete your 5 documents. Sorry. Sit down at your kitchen table with writing materials and a notepad. Work through this checklist systematically. Mark off each document you currently have in place. Draw a circle around each one that is missing. Number 1, durable financial power of attorney. Number 2, last will and testament containing explicit instructions regarding your home. Number 3, transfer on death deed or revocable living trust properly funded. Number 4, advanced healthcare directive incorporating both a living will and a designated healthcare proxy. Number 5, homestead or senior property tax exemption application. If even a single item on this list is absent, a gap exists in your protection. And gaps are precisely what cause families to forfeit their homes, their accumulated savings, and their peace of mind. For documents requiring professional assistance, contact the Elder Care Locator at 1-800-677-1116. This federally supported service is provided at no cost to individuals over 60 and will connect you with qualified free legal help within your geographic area. That number once more, 1-800-677-1116. Step 2. Deliver your documents to the appropriate people. Completing a document and placing it in storage is entirely insufficient. Your durable financial power of attorney must be registered with your bank and your financial institutions before any emergency situation develops. The Consumer Financial Protection Bureau specifically cautions that financial institutions may decline to honor a power of attorney they have not previously reviewed and approved. Do not discover this limitation during a moment of crisis. Your advanced healthcare directive must be physically in the possession of your physician, your hospital, your designated healthcare proxy, and at minimum, 1 additional trusted family member. Additionally, visit your My Social Security account at SSA.gov and establish your advanced designation of representative payee. Identify up to 3 trusted individuals by name. This service is free of charge, requires only a few minutes to complete, and has the potential to prevent an extraordinarily painful and costly situation from developing. Step 3. Review and refresh everything on an annual schedule. Circumstances evolve, people change, laws are amended and updated. The individual you designated as your agent several years ago may no longer represent the right choice for your current situation. The will you executed before a divorce may direct your home to someone you have no current intention of benefiting. Establish a fixed date occurring once annually, perhaps your birthday or the first day of a new calendar year, and dedicate that time to reviewing all 5 documents. Confirm they continue to accurately reflect your current wishes. Verify that the appropriate people still hold current copies. Confirm your property tax exemption application has been properly renewed. This single annual practice may ultimately prove to be the most consequential protective action you take on behalf of your home and your family. Before concluding, I want to say something that genuinely matters. What I have shared with you throughout this presentation has the real potential to transform your retirement outcome. It can protect your property. It can shield your family from courtroom disputes, unexpected tax burdens, and devastating financial loss. But here is the reality you need to acknowledge. The government will not send you reminders to complete these documents. There is no automatic notification when regulations change in ways that affect you. And YouTube's algorithm determines what content reaches your screen, not your own preferences or your actual needs. This is precisely the reason I created something specifically for you. This channel delivers real-time alerts whenever meaningful changes occur to Social Security regulations, Medicare policies, pension legislation, banking rules, insurance guidelines, or travel considerations affecting seniors. No unwanted promotional content, no commercial interruptions, simply clear, verified, time-sensitive information delivered directly so you are never left uninformed or unprepared. Click the link provided in the description right now. Join the channel community, download your complimentary guide, and share this video with someone important to you who owns their home and has passed their 60th birthday. Because the 5 documents we examined today provide no protection after a crisis has already arrived. Their power exists exclusively when you file them before the emergency occurs. My name is Floyd. Thank you sincerely for watching. I will be with you again in the next video. Stay safe, stay informed, and protect everything you have worked your entire life to build.